this morning's docket. Case number 106409, State of Kansas v. Jordan.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Michael Jordan. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is a case out of Sedgwick County involving a situation where we have two trials. One trial where Mr. Jordan was convicted of several traffic offenses when he was caught in a Mercedes in Sedgwick County, and then subsequently tried for theft of that Mercedes. So the issue in this case is compulsory joinder under KSA 213108. The tests are pretty clear in the application in this case that there's a three-part test. Has a person been convicted or acquitted in the previous case? The answer is yes. He was convicted of some of the traffic offenses and acquitted of one of the traffic offenses. The third part of the test is whether he could have been tried of the subsequent offense in the first case, and it's important to note these were both before the district court. Although the first case was in the traffic division of the district court, it's the district court. So the district court had or could have exerted jurisdiction over this case. So the answers to both of those questions are yes, and we're left with the answer that we briefed. Was there evidence of the previous crime brought out in the first prosecution?
And Mr. Hodgkinson, can I just clarify exactly what was before the court as evidence in the first case? I understand that the police report went to the court. Was there any other information, any other evidence in the first case? That there's a reference to stipulation. Did it include anything other than the police report?
I don't remember, and I know I don't cite to anything else, and I don't have any evidence that any other part of that, if there was anything else, contained any evidence. I'm not able to claim that today in any case.
So the only evidence that we know that might be overlapping is in that police report.
That's right.
Very good.
And so we're blessed in that situation too that we're in agreement on what we're talking about here, and it's this stipulation of this police report, which states that that the tag was reported stolen. The officer obtained the identification number from the vehicle and found that it was reported stolen. The vehicle was reported stolen under this case number. The vehicle was a 2005 Mercedes-Benz with the vehicle number owned by Joshua Smith. So the question before the court is that evidence that the Mercedes, of theft of the Mercedes? If it was, then compulsory joinder rule would apply.
Isn't it the by deception piece that you're also talking about?
That's certainly what the district court and the Court of Appeals, I think, latched onto, is the fact that it doesn't say how it was stolen, that some part of that. And so I'll bifurcate my argument as I did in the brief here to say, first of all, under the test that this court has sort of announced in the past, which is a sufficiency test, is there sufficient evidence of theft, or is it theft by deception in this case? And again, the court knows the test. I don't think I need to explain it a lot.
You don't like Wilkins?
I'm sorry?
You do not like Wilkins?
Before I get to that, but yeah, I don't. I mean, I would ask this court to overrule Wilkins, but even assuming Wilkins is the law, I've made a lot of sufficiency arguments. And so, I'm fairly familiar with that, and I know that it's not the law that the prosecution, when proving a case, has to have every detail. That sometimes there are things like a girl testifying, he molested me, and does that support, conviction for various kinds of sex crimes, things like that. And so, when you bring to bear even the sufficiency test on this, is evidence that it was stolen, that it was a Mercedes-Benz owned by somebody else. Is that evidence that it was theft, prior theft? And the answer we think is yes.
And have we applied Wilkins to mean that there has to be sufficient evidence in the prior proceeding of the precise crime that's being prosecuted? What about a lesser included? Like we have, because obviously that would be enough to draw an inference that we have a criminal deprivation of property scenario, or possession of stolen property scenario, or some other kind of thing. But if we applied it strictly that the prosecutor can avoid the compulsory joinder by the way in which the second crime is charged.
The test is set out in Wilkins is there sufficient evidence of the crime in the second prosecution, I think. And so the second part of my argument is, that being the test, we would argue and ask this court to revisit that test for the very reasons you're sort of stating, Justice Johnson, that if that's the case, that the prosecution can avoid the application of this statute by, for example, just leaving out one element maybe of some crime, then we have to view this through the purpose of, I think, the contemporaneous of the compulsory joinder rule, as stated by this court, which is to encourage, like every compulsory joinder rule, to encourage litigation in one case and avoid multiple trials. Well, that's exactly what happened in this case. And this case is a good example of why the Wilkins rule isn't doing that job. Because if the state can just merely make sure that they surgically leave out one element and therefore render it insufficient and outside the scope of the compulsory joinder rule, it's going to encourage multiple trials. And this court has said that's not what that statute is supposed to be about. So we would ask you to revisit that test.
What is your test any evidence?
That's my test, and that's what the statute says. It says evidence of the prior crime without any qualification. And so, yeah, that's exactly what I would ask you to do, is read the plain language of the statute. If the legislature wants to have a qualifier on there, it can put a qualifier on there.
So the name of the defendant, the location, for venue purposes, just anything like that. And the second you touch anything about another crime, you're done.
Of another crime, yeah, then you're done. And that would further the purposes of the statute to say, if you have that evidence, let's get it together. Move to amend, add that count in, let's do it all in this trial. That was the stated purpose of this statute. And if the evidence is insufficient in a case like this, and this is the way it works, we're really working around that stated purpose. I think that Your Honor, I glean from you, I feel like you're like, well, that's kind of absurd. Or possibly could be absurd.
It's the opposite absurdity of your point, which is all the prosecution has to do is leave out just a little tiny thing.
Yeah.
And they're good. And you're saying if they put in just a little tiny thing, they're dead. And it seems like there ought to be a different ground.
Yeah, and I haven't, and neither of us have really espoused, is there a middle ground somewhere? I don't know if this court could divide that baby in some way to a middle ground that's less than sufficiency but more than what I'm talking about. I don't know.
Because it really seems like you could never do it under your test. Because by definition, the first trial is going to have location in it. It's you're going to have something.
Yeah, maybe I would have to qualify it in some way to say, not that last line of the elements instruction that it occurred on this date in Sedgwick County. That's not evidence of the crime. In fact, it's not. I mean, that's venue.
But then you get into, well, what's the statute say? Does the statute really, can we look at it and say, your interpretation is what the legislature intended from a fair reading of the text?
And it's where I come back to, and I cited in the brief the idea that, this court in other applications has said that kind of thing with regard to possession of a controlled substance. And we've come in and argued, if it's an unweighable, unusable amount, that's not possession. And this court has said, the statute doesn't have a qualifier in it. And so we're not going to put one in. And so that's where we come to this court saying, we'd like you to apply that same kind of interpretation to this statute. And if that's wrong, then the legislature can fix it.
Is there anything that the state could have deleted from this police report from the first trial that would cause you to say, okay, I have no basis to argue 31082A.
Sure, if they remove all the evidence about the make of the car, the owner of the car, that it's stolen, that it's been reported stolen, taking all that out, he's driving a vehicle, and these were the traffic offenses that occurred while he's driving a vehicle. There's no evidence of a crime in there. No evidence of a crime in there.
The stolen vehicle had nothing to do with the traffic infractions.
No, Your Honor.
We have sort of struck a middle ground in the Mullen case that was talking about the purpose, and it said to prevent prosecution from substantially proving a crime in a trial in which the crime is not charged, and then in effect retrying the defendant for the same offense in a trial where it is charged. That substantially proving seems to me is somewhat less than the substantial competent evidence of Wilkins, but more than they both happened in the same venue.
And I could see it. I could definitely see a workable rule in the middle, and we haven't really argued it very well. Maybe it's something we would need to brief more. That talks about more what are the substantive elements of the crime of the subsequent prosecution, as opposed to things like venue or the date or things like that. Are those involved? Is there evidence of that in this? And clearly the answer is yes in this case, right? The car was stolen. It belonged to somebody else. It was just sort of the specific subsection of theft that we're dealing with here. That if there's any insufficiency, that's where it is.
Any further presentation?
No, Your Honor.
Any more questions?
Thank
Thank you,
Your Honor.
counsel.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. It is our position in this case that once again, the Court of Appeals was correct. We believe that Wilkins does apply here. We do not agree that Wilkins should be overturned. We believe that the test in Wilkins is workable, and what you need here is a workable test. And in Wilkins it said that for the second prong to be satisfied, the evidence presented at the earlier trial has to be sufficient to support a conviction sought in a later trial.
How do we get around the plain language of the statute, as opposing counsel has been adroitly pointing out?
Well, I believe that's what this court did in Wilkins, and interpreted it to be sufficient evidence. I agree that the statute just says evidence of, and if you're going to go with the plain language of the statute, as Justice Biles said, that could be a defendant's name. It could lead to the absurd result where if for some reason maybe a defendant was loitering outside of a Walmart, received a ticket for loitering, came back, he was upset, kills somebody. For some reason, if there's evidence from the murder dealt with in the loitering, if these are dealt with separately, that does away with the murder charge. I think that would be the absurd result, and I think you could come up with different hypotheticals where you would get an absurd result if it's some evidence. The other thing...
Isn't that up to the legislature to change the language of the statute?
It is, but we haven't had a problem with this test. Wilkins, I believe, has been around since 2000, and we've had no issue with it. And with the test in Wilkins, sufficient evidence is something quantifiable. We know that sufficient evidence, what that is, based on the elements of the crime charged. So you can look at that to see if sufficient evidence was presented in the previous proceeding. If it's just some evidence, you're going to be arguing, the parties are going to be arguing, nor does the statute say it has to be the state presenting this evidence. So what if defendant in the first trial mentions something that relates to the other charge? Does that mean it gets thrown out because the defendant said it? it doesn't indicate who needs to present that evidence.
What conclusion then, if any, can we draw from the fact that Wilkins is 15 years old and the legislature has not changed the statute that Wilkins interpreted the way that it did?
We could interpret it that they've seen that you've interpreted it and they don't believe that they need to change the language. And that Wilkins has set out what needs to happen in a case regarding compulsory joinder, and the legislature's determined they don't need to add language because there is precedent interpreting their language.
Are you aware of any efforts that anyone in the legislature has taken to try to amend the statute?
No, Your Honor, I did not look into whether anyone's attempted to change the statute.
Thank
Have
you.
you taken
Under
a-
plain,
Oh, excuse me, go ahead.
under plain language, what does it mean, evidence of a crime?
Well, I
It
believe,
says, is for a crime or crimes of which evidence has been admitted. So I'm kind of flipping it a little bit, but it's evidence of a crime. Does that mean to prove to prove a crime, you have to show the various elements? Each
Well,
of the elements?
and I don't recall, I would have to pull it up, but what I have written down is that evidence of the present crime must have been introduced in the prior prosecution, and then going to the third step, the charge in the second prosecution must have been one which could have been charged as an additional count in the prior case.
Those are the burglaries.
That's,
Those are the factors, but I think Justice
I'm-
Luker's directing you to the statutory language.
And if the statute, because our position is, I think one of the questions earlier was, can it be evidence of any crime? And I don't recall exactly if the statute just says evidence of a crime.
Counselor, the statute says, and the subsequent prosecution is for a crime or crimes of which evidence has been admitted in the former prosecution and which might have been included as other counts in the complaint, indictment, or information filed in such former prosecution.
And I would interpret that as evidence of being the charge that's charged in the second prosecution.
Right.
The crime being, and that comes with the question earlier was about any crime, and here the crime charged, and I may be muddling this, but the crime charged was theft by deception. So our position is it would have to be, it's not just evidence of theft in the traffic case, it would have to be evidence of theft by deception. And I don't know here, it's our position that there was not. Was there some evidence, if you want to follow if you want to ignore Wilkins and follow the strict language of the statute, was there some evidence of theft? Well, it mentions a stolen car, that he was in a stolen car, and it mentions the owner of that car. But was there evidence of theft by deception? It's our position that no, and that was the crime that was charged in the second trial or case.
To
I
be
don't know.
compliant with Wilkins or to definitively support Wilkins, the statute would read crimes which were proved in the former prosecution. You indicate it doesn't say some evidence, it just says of which evidence was submitted, but it also doesn't say the crimes were proved in the former prosecution. And so we have two constructions of this statute, both of which could be reasonable. And what does the rule of lenity tell us?
Well, going back to that, and that I don't believe was argued here by counsel, but that would be if there is a question as to the meaning, and I don't believe there is a question as to the meaning here. I believe that this court created a workable test in Wilkins by stating that the evidence needed to be sufficient to support a conviction, and I believe it even states that it's in the light most favorable to the defendant. So we're not even looking at the light most favorable to the state. So in the light most favorable to the defendant, was the evidence sufficient to support a conviction that's sought in the later trial? And I believe that is a workable test because, as I said, we know what sufficient evidence is because that is based on the elements. If it's just evidence, can that be anything? I think that is not as workable as the test that we have in Wilkins today.
That's a pragmatic argument. Did you, not a statutory construction argument really, just a pragmatic one. Did you take a look at any of the support that Wilkins cited for this rule? Like the Spring article or
I did not,
Edgington or
not
Barnhart?
look at the article. I do know that it cited Barnhart.
in Edgington?
And where Barnhart has stated that the legislature has intended the state to have two choices. And what occurred here is one of the things that the state is allowed to do. Choices to either one, consolidate the two cases or charge all crimes in one charging instrument, whereby evidence of all the crimes charged would be admissible, or two, the state can elect to have separate trials and not use evidence of the second offense in the first trial. Second is what
And that
happened
was
here.
possible here. Let's just return to that for a moment. That choice was possible, right? There are elements of that police report that could have been stricken from it or blacked out or deleted, and you still could have proved your traffic offenses, couldn't you?
True.
Okay.
But the legislature has said we have that choice. That choice has
But
not
only
been.
if you refrain from using evidence to be used in the second prosecution. You don't have the separate prosecution's choice. That's the whole idea behind the rule.
I understand that, and that takes us back to Wilkins.
You need Wilkins to prevail. And that's why I asked you if you looked at the Spring article.
No,
Because I
but
don't think it supports the proposition for which it's cited.
I see. Well, even the district court, I mean, this case is based on Wilkins. I believe when the district court made its ruling, it even cited to Wilkins.
Yeah.
So if that has changed, yes, I mean, there's evidence here.
Okay.
Was the police report admitted into evidence to prove the theft by deception?
At the theft by deception
Second
trial, to my recollection, I believe the second trial was a bench trial, and I believe testimony was taken from the victim, the owner of the car, the officer, and maybe even a detective who did a photo lineup. So I don't believe that the police report was entered for any reason. I believe that all came in through testimony to the court.
We have a record in any event of what went in.
Yes, I believe that should all be in the record, because when I looked back through my notes, I had notes from a trial. So I think there were at least 3 witnesses. It wasn't lengthy, but I think there were 3 witnesses.
Okay.
So unless there are further questions, our position is that the Court of Appeals did get this correct, that Wilkins controls, that there was not sufficient evidence to support a conviction of theft by deception presented at the first trial. There was no evidence regarding the defendant's intent, whether he took control of Smith's vehicle by deception, whether the vehicle was valued between $1,000 and $25,000, the date that the alleged theft occurred, or the location of the theft. None of that was shown in the police report that was admitted in the traffic case. So we would ask that you affirm the district court's conviction here and uphold Wilkins.
Any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Your Honor, I don't have anything else in response to my colleague's presentation unless the court has questions.
Any questions?
Just a quick one. Do we have to either overrule or at least modify Wilkins for you to prevail?
Well, no. I mean, our first line argument is that even under Wilkins, the evidence
You're not
was-
abandoning that.
I'm not
that
abandoning
first
that.
line attack. Okay.
I was thinking when my colleague was up, especially about Justice Johnson and Justice Biles' questions of, it may be though that you don't have to overrule Wilkins for.
So
my
you would
client
say
to
that
prevail.
police report would be under a sufficiency test, would be sufficient to support, the police report by itself, sufficient to support a conviction for theft?
It would be sufficient to support one or more substantive elements of the crime of theft that was substantively
Well, but if you
prosecuted.
were here, if your client had been convicted, as he was, of theft by deception, and the only evidence that the state put in was that police report, you would raise a sufficiency claim, wouldn't you?
I think I would.
Would it be a good one or not?
Well, and that's why I'm saying I think maybe you could modify Wilkins to say.
Okay, so we do
is
have
it
to
sufficient,
modify.
Sufficient evidence, not necessarily of the entire crime.
Right. Maybe we don't have to
But one-
overrule Wilkins, but we have to at least modify it.
Or explain it, clarify it.
Any more questions?
Yeah, I want to clarify. I understood you originally to say that the evidence presented in the first trial would be sufficient if one were to draw inferences like we often allow. Now you're saying that maybe that wouldn't be permissible inference?
Your Honor, the justice has asked me a question on if I was arguing on the other side of
Yeah,
this, what
right.
would I be arguing? And I have to acknowledge that in certain positional conflicts, we argue differently. Certainly, my experience is when I raise sufficiency issues, I understand that threshold is very low. What would I argue in a future case? I'll have to wait till a future case here.
I understand.
That's why I
But
asked you about whether anything but the police report came in the first time around, because what we don't have are a couple critical points on deception. We don't have the fact that it was a test drive, and we don't have the fact that the car disappeared for several days with no explanation, both
That's-
of which obviously contribute to the deception part.
Yeah, and that's why even as you're having the discussion, I wonder if it's the test, and this could be consistent with Wilkins, is sufficient evidence of one or more of the substantive elements of the crime.
I'm trying to figure out if the traffic report would support any element of the theft by deception at a trial.
Sure.
You have got to bring a guy in to say that's my car, and my car is worth X, and I mean, in other words, the traffic report may document hearsay of certain elements that would have to be proved in a later crime, but is that traffic report really evidence of the crime of theft by deception?
It certainly is evidence, because in order to prove theft by deception, I have to prove that a person has control over property of another with the intent to deprive them permanently of that property.
Right.
Now, how you do that is whether it's theft by deception or theft by exerting or something else. One of the other versions. So
The police
is this?
report only says somebody reported this.
Well, it says it was stolen and that it belonged to somebody else, and those are substantive elements of even theft by deception.
But the report doesn't prove those facts.
It's evidence of those facts. Though.
Evidence of those facts.
It's not admissible at the subsequent trial without more. I think that's where we're talking past each other. It's evidence, but would it be admissible evidence at the subsequent trial?
It's clearly evidence of one or more of the substantive elements of theft by deception.
I'm a little confused then on what your position is. I initially had in my notes something I think you acknowledged, and that was your first position was that even if we apply Wilkins, your client wins.
That's right.
And then it sounds like you're backing away from that a little bit now, and we would not just leave Wilkins as is, but in response to one of my colleagues' questions, you acknowledge that we probably should be at least slightly modifying Wilkins.
Your Honor.
Where are we on that?
My arguments are, first of all, even under Wilkins as it is, we should win. In the alternative, I have argued, primarily in the brief, that under the plain language of the statute, Wilkins should be overruled. My last comments here, sort of as we've had this discussion today, and especially in response to Justice Biles' questions, is that sort of absurd or too far on the spectrum, that there may be a middle ground still that would still result in my client's relief here, is I don't have to show evidence of completely overruled to any evidence, but evidence of substantive elements of the crime.
Of at least one of them?
one or more
one or more.
of the substantive elements of that crime, that would be a middle ground that would resolve a lot of these issues.
And how
I just
much-
brought that up as we were talking
And,
about it.
and
here.
what level of evidence would be required
Sufficient evidence of one or more of those elements.
as if it had been a conviction?
That's why I said I think that could be consistent with Wilkins, just explaining it or clarifying it.
All right, thank you.
Which,
you, Your Honor.
which obviously would be a deviation from plain language, which is a compromise of your original position. We don't need to go back all through that. Isn't the Wilkins standard worded that the defendant has a burden to show would have been convicted, even greater than could have been? Would have been sufficient to convict or something. I mean, it's pretty strong. It's pretty strong medicine, as I recall.
Well, it's the sufficiency test. I mean, a sufficiency
Right, but
test.
it's like sufficiency plus, if I remember the wording.
Would lead a rational fact finder to find
Yeah,
the defendant guilty
As
beyond a
opposed to
reasonable doubt.
could. I mean, sufficiency is, could a rational fact finder have found guilty, right? That's what that's that low burden we're always talking about.
Yeah, I see what you're saying, Your Honor. I haven't thought about that distinction.
That's mind-blowingly high, really, for a
If that's true, you're right.
Okay, thanks.
Any
Fair
more,
air grounds.
any more questions? We're now in the afternoon. Thank
Thank
you,
you, Your Honor.
counsel. Thank you both for your arguments this morning and this afternoon. Clerk will take this matter under advisement. We now